Hello and welcome to Tilting at Powerlines, local control of large energy development. I'm Sarah Meridian, as you can see. I'm the Government Relations and Policy Director for CURE. And for those who aren't already familiar with us, CURE is a rurally based nonprofit dedicated to protecting and restoring resilient communities and landscapes by harnessing the power of the people who care about them. Our work covers a lot of topics, including energy, water, natural and working lands, and rural democracy. And at CURE, I specifically practice before the Minnesota Public Utilities Commission and work a lot with rural electric co-ops to encourage better energy democracy that furthers resilient and environmentally sound energy build-out. Before we begin, I do want to acknowledge that CURE's work takes place in many rural spaces across Minnesota and the upper Midwest, which are the traditional and contemporary territories of Native nations, including Dakota and Ojibwe tribes in Minnesota and the Dakotas. These tribes have rights and knowledge tied to the land that are relevant to county land use decisions and economic development, either as historic preservation experts, project proposers, or construction companies installing new infrastructure. Tribal members and businesses will continue to be central to the discussion of counties' policies and projects. Partnerships with tribes and their expert agencies foster the development of better projects that are completed more rapidly because working together instead of in opposition is always more productive. Next, I've got a couple housekeeping items. This webinar is being recorded, as you know. We will send out the recording, so please feel free to share with attorneys in your county for the free Minnesota CLE credits. Speaking of which, we've got some codes for you. If you are attending the webinar live, the CLE code is 503970. Again, that's 503970. If you are watching the recording of this webinar, the CLE code is 503929. We'll put those in the chat and also remind you of them at the end of the webinar too. And then for those who are watching the recording for Minnesota CLE credit, this course is cleared for 1 hour of credit through April 24th, 2026. So make sure you register it by then. And then if viewers for on-demand credit have any questions about the content, please contact me and I'll be happy to try and answer them or get you those answers. Lastly, we will have time for Q&A at the end, but please feel free to put any questions in the chat or use the Q&A function during the webinar as well. So now that that's all done, let's get started. The growing climate crisis means that we are going to need to transition to renewable sources of energy as soon as possible. But we also know that by and large, this is going to mean that new energy infrastructure will be built in the rural places we love and call home. We've already seen how this dynamic can play out across Minnesota to both the benefit and detriment of our communities. For example, at CURE, we often reference the book Powerline by Barry Casper and Paul Wellstone, which describes the conflict that arose in the 1970s out of the construction of a 430-mile high voltage transmission line from North Dakota to the Twin Cities. And that conflict kind of arose between the utilities, the state, and then communities along the route. More recently, we've seen some local governments respond to an influx of proposed solar and wind development with moratoriums or permit denials. Others, like the city of Morris, have taken a different approach, working with partners from the University of Minnesota to local health agencies and local, state and national nonprofits to actively engage in deciding what technologies are used, where and how they are sited, and how the community was going to benefit. The permitting of renewable energy projects has also taken center stage at the state level. The Minnesota State Legislature is currently considering an energy permitting reform bill with the stated goal of speeding up permitting timelines for clean energy projects. CURE has been working with the bill authors and legislators to ensure that the language of the bill does not erode the public's access to information or their ability to engage in these processes. These conversations about when, where, and how we build out renewable energy and the grid sit squarely at the intersection of CURE's most important work on rural communities, energy, climate, and democracy. So today, we're going to dig into local landowner benefits and costs associated with clean energy development, discuss how local and state policy choices shape these impacts, and explore some policy options that may offer a more fruitful and fair pathway for siting clean energy in rural places. Local leaders and their council have good options to get ahead of these issues and guide positive development of these kinds of projects without shutting the entire conversation down. So to talk more about some of these options is Derek Broughton, who is the owner of Broughton Law Firm in North Dakota. Derek's Minnesota, North Dakota practice has always centered on providing legal services to family farmers and ranchers and other private landowners. Derek's practice focuses on standing up for landowners and the land, whether it's forcing an energy developer to clean up a spill or protecting private property rights from government overreach. Derek handles many matters in this area, ranging from negotiating pipeline easements and wind leases to complex multi-jurisdictional litigation against large oil and gas exploration and production companies. So with all that said, I will now turn it over to Derek.
Great. Thank you, Sarah. And I'm going to give just a little additional background covering some of the same ground as Sarah. But the other thing I want to do is give you a little of my background just so that you have the perspective of where I'm coming from on some of these issues, both from a legal perspective as well as a policy perspective. And I'll be upfront, that I'm an advocate of local control, for example. And so I support the local governments in the work I do. My practice, as Sarah said, is actually less focused on government work, and the majority of my practice focuses in on property rights, and specifically property rights at the intersection of energy and natural resource development. And I also usually say that 90% of my clients are individual farmers and ranchers. And sometimes other landowners, maybe someone who's retired from farming and still owns the land, but essentially it's the folks on the land. I also do work for, various nonprofits. That we have a landowner association out in North Dakota, and I do a lot of work with them, whether it's putting on conferences or seminars like this or actual litigation or lobbying at the Capitol. But I do, because a lot of that work, particularly with the local landowners, farmers, ranchers, we often look to local governments in some of the representation I have with the landowners. And so because of some of that work, I've become an advocate of local control, and I've worked on that, but I've also work directly with some of the local governments. And so I'll just give you a real quick rundown of just a few recent matters so you have a sense of what I've done in this context. And so Sarah mentioned some of it, but I've also real specific to the local government issues and what we're talking about. I've worked with townships and counties on regulation of concentrated animal feeding operations, or CAFOs. As well as with landowners. I've worked with townships and counties on regulation of radioactive waste facilities. And that's something I'm going to talk about, a specific story about one later, because I think they had it as a really good example of how to do things. But these radioactive waste facilities are essentially radioactive waste that comes out of the oil patch and goes to a radioactive waste dump. And as you can imagine, there's a lot of folks who don't want that next door. And so a lot of those discussions take place at the local government level. And specifically, there was one where a local government used a moratorium, but with the goal of developing a model ordinance and then following through. And that's one of the stories I'll talk about later. I'm also currently representing a local government out in North Dakota, the Summit Pipeline. I'm sure everybody knows plenty about. But that pipeline is going through our Public Service Commission citing proceedings, and there's a number of local governments that have intervened because it's coming through, and there's an issue about whether the state citing or the local setbacks apply. And so we're arguing about that right now out here. And if you've been following it, these similar fights have played out in Iowa and South Dakota and other places related to these kinds of newer pipelines, but really pipelines in general. This has happened. So what I want to talk about initially, and I'm going to do some stuff that's going to be legalese, and I think, I'll get in the weeds a little bit on these cases, but what I want to just sort of say up front is that I'm going to talk about a few specific cases, and as attorneys, we look at a reported decision where a court decides a case and decides the issues and writes an opinion about that, and that's what we refer to as a case. And those opinions are really where we set out, or where the courts have set out some of the law that applies to the issues of who has jurisdiction. Is it the county? Is it the state? Or is it the federal government? Is it all three? Is it a combination? And that's always the question. And so I'm going to talk about, just because we're in Minnesota now, I also should mention I'm licensed in both North Dakota and Minnesota. I also practice Montana, South Dakota. And so I'm somewhat familiar with all of these states and their laws, even though my primary practice is North Dakota. But I'm going to give you the Minnesota law, which is pretty much the same in a lot of different states, and explain that. And then my main point with it is going to be to explain that there are no real great generalizations in this context, and it's always a very fact specific issue. And so I'm going to use a couple of cases just to sort of illustrate that. And again, I don't expect that everyone is going to remember every little detail of these cases or every point of law I cover, but my goal is more to give you just a flavor of how fact specific these fights can be. And I'm going to talk about like I said, a couple of cases. One's a North Dakota case, one's a Minnesota case. And then I want to explain a little bit about that experience we had out here where there was a county that was dealing with one of these radioactive waste facilities and didn't have regulations. And there's also a new facility right now in Morton County I've been working on, a direct air capture. And they're facing a similar issue where they're looking at the zoning and saying, well, we don't really have anything on the books for this. And so I want to talk about that in the end, as how do local governments deal with this when you see these things coming in. And so we're talking a lot about clean energy infrastructure, but these same issues have come up in the past before, we're seeing a lot of clean energy development, and whether it's fossil fuel development or what I mentioned earlier, concentrated animal feeding operations. Essentially, what I would say is anytime you have either industrial type or commercial type or land uses that may have an impact on neighboring properties, you're going to see some local government fights going on around that. And so these disputes, it's new to have them going on around the clean energy infrastructure, but having disputes about energy infrastructure and local government jurisdiction is not new at all. So I'm going to try and screen share here so I can just show you some highlighted portions of cases. So oops. So Sarah, maybe I can just ask you, but I've got a PDF with some highlighting in the Jennison case. Is that the screen that's showing right now?
Yes. Yep.
Okay.
It sure is.
Okay, great. So the Jennison case is just one of numerous cases. You could go out and find another dozen of these that say something similar, but I just wanted to grab a fairly recent case from the Minnesota Supreme Court that set out the basic standard for what we call preemption analysis. And preemption analysis is essentially a question of the other way we refer to it as conflict analysis. So the question is jurisdictional. If you have a situation where a local government, a state government, and a federal government, or a combination of them, all have jurisdiction over the same project, the question is, how do you sort of ferret that out and decide whether one entity's jurisdiction trumps another? And it is one thing I want to say, a lot of people have the assumption or make the assumption that the preemption analysis is based on the level of law, meaning that state always trumps local and federal always trumps state. That is not the case. That's not true. It's much more complicated to make those determinations. And that's why I want to talk about a couple of actual cases to illustrate that. But the three kinds of preemption very basically are, and this is the most law I'll give you, the rest will be facts, but I'm going to give you a little law here. Express preemption. And then there's two kinds of what we refer to as implied preemption, and that's a little more tricky, but there's conflict preemption and then there's field preemption. So when we go to this case, I'll explain each one a little bit, but they give you a pretty good description or definition in here. And so express preemption occurs when the legislature has expressly declared that state law shall prevail over municipal regulation. In this case is specifically talking about the difference between state law and local law. So express is when the state legislature says we intend to preempt local laws. And I'm going to talk about a statute for the PUC pipeline siting that says that, but then we're going to talk about what it preempts and the words it uses, because that's detailed too. There's also conflict preemption, and I'm going to talk about a case in North Dakota that deals with this in a way and illustrates what that means. But it's when state and local laws contain express or implied terms that are irreconcilable with each other. When local law permits what the statute forbids, or when local law forbids what the statute expressly permits. So a state law says you can go ahead and put that facility there, and the local law says, no, you can't. That might be a conflict. It depends also, though, on why they're saying you can or can't put a facility there. And I'll get into that with setbacks on pipelines. And then there's field preemption, which occurs when the legislature has comprehensively addressed the subject matter such that state law now occupies the field. And again, there's another, or the North Dakota case I'm going to discuss gets into a little bit of field preemption as well. And it's in the context where that often happens, or in a context where that often happens, which is oil and gas development. And specifically, you know, in North Dakota, we've got a lot of oil and gas development, and the state has taken most of the regulation of oil and gas and put it in the hands of our oil and gas division and taken that very explicitly away from local governments. So those are just a very quick synopsis of the three kinds of preemption and the different ways we look at whether there is a conflict between the local law and the state law, or whether one of them trumps the other, or whether they both can regulate. And the reason I wanted to bring this up is it's, again, I don't necessarily expect that everyone's going to remember this and you know, have it imprinted on their mind now, but as I go through and then show you how the courts have applied these rules, my goal is to show you that there is never a categorical generalization that can be made about local authority or state authority. Can't make generalizations. Got to apply it to the facts. And I say that because I've been involved with a lot of disputes that involve local governments. And I always, not always, but I often hear statements about, well, counties don't have any jurisdiction in this situation, or counties have no jurisdiction over those pipelines. Rarely, if ever, is a statement like that true. It's almost always gray. So my goal here is to make everyone think, if anyone is telling you a simple categorical rule that applies to all county jurisdiction, that's probably not right. It's not simple, and anyone who's got a simple answer to county jurisdiction is oversimplifying. So what do I mean by that? I'm going to talk about a North Dakota case. I want to make sure my screen flipped. So Sarah, I guess, are you now seeing the environmental driven solutions case with?
Yes.
Okay.
Yep.
So the environmental driven solutions case related to a treating facility, and a treating facility is a defined type of facility under our law. And it's a defined facility under these statutes and regulations that are administered by the North Dakota Industrial Commission. And the Industrial Commission has what we call an oil and gas division. And that's the main regulator of oil and gas development in the state. As you can probably guess, oil and gas regulation is one of the most highly complex areas of law that exists. And it's because they have to combine the law, which is not simple and often very complicated, with fluid dynamics and reservoir engineering in dynamic reservoirs that are actively being produced, which is extremely complicated physics. And they've got to put together law and physics in a way that allows them to produce oil for this country. And it's extremely complicated. And because of that, we want to have a specialized body full of geologists and people who understand all of the fluid dynamics and so forth, being the ones who are administering those regulations. So I give you that context because it's within that context that you have to understand this case, which was a dispute between Dunn County, a local government, and the North Dakota Industrial Commission and a project developer who wanted to put in this treating facility. And the basic facts are that the project developer, Environmental Driven Solutions, went to the Industrial Commission's Oil and Gas Division, and the Oil and Gas Division permitted them to locate that treating facility in a particular place. They were moving ahead with that, and then Dunn County, they had applied for, I believe, a conditional use permit, but they'd applied to Dunn County, and Dunn County essentially said, no, you can't put it there. We don't want it there. And the project developer then sued Dunn County and said, we want the court to rule that you don't have any jurisdiction over our facility and that we only need to get our permit from the Oil and Gas Division. They won that, meaning the developer won. The Industrial Commission came in on the side of the developer into that case and submitted arguments on their behalf. And so you essentially had Dunn County versus the state of North Dakota and the industry. And I will say up front that I'm going to tell you what happened in this case, but if you know enough lawyers, you'll know that just because the courts decide a case a certain way doesn't mean we agree. We usually disagree. And so I don't agree with how this case was decided. I think this court got it wrong, but whether I think that or not is irrelevant because now this is the law. So it's important though, and I think the reason I disagree with it is that they just gave an incredible amount of deference to the Oil and Gas Division. And frankly, I think the county had jurisdiction here too. But there's a reason they rest their decision here, or there's something they rest their decision on, and it's some of this highlighted language. It's unusual for a state agency, but our Oil and Gas Division, its powers are what they call continuous and exclusive. And so what our legislature has said basically is when the Oil and Gas Division is acting in the realm of oil on anything they're doing is exclusive. You don't get that clear a statement very often that's that sweeping for an agency, but because we have that and these very high levels of deference for the Oil and Gas Division, that's partly what happened here is the court is giving them a lot more deference than they would to other state agencies. And that's true in Minnesota or North Dakota. So the Minnesota PUC, for example, wouldn't get quite that level of deference. But what the statute the Oil and Gas Division administered said was that one of the things they can look at, and this is my problem, is if it said they had to look at this, that would be a lot stronger. But it just said they may look at this. It said they may look at the safety of the location and road access to the treating plants. And so eventually that's what the court used to say, well, if the Oil and Gas Division is determining a location or the propriety or the appropriateness of a location, that means that's exclusive and no one else can do that. Therefore, to the extent Dunn can, this goes back what I said earlier, is there was a conflict preemption. If you can comply with one but not the other, that's a conflict. And then I also talked about field preemption, which is if an agency or a state regulates everything in that field, no one else can. Well, that's kind of a combination here. And what they were saying is that first off, because the Oil and Gas Division's jurisdiction is exclusive, if they are regulating something, no one else can regulate that thing in a way that leads to a different result for the developer than what the Oil and Gas Division said. The Oil and Gas Division said you can put a treatment plant right here. Dunn County said you can't put a treatment plant right here. They couldn't put the treatment plant where the Oil and Gas Division told them to and comply with Dunn County's order that they can't put it there. Therefore, there's a conflict. Additionally, because it's oil and gas, the courts are also very likely to say anything oil and gas Division occupies the field, they cover everything. And so this, what I would say is when we saw this case come down out here, we thought it was a mighty blow to local control and local government. But what I would say is that I have heard, and this is going back to my earlier comment, that beware of generalizations. So I just had a facility out in Morton County that's applying to the Morton County zoning. You don't need to know where this stuff is, but there's a county out here that's got a project. And the project is a direct air capture project where they're going to build a 40 megawatt power plant, gas plant to run fans. And then the fans blow air through this sorbent material to gather the CO2 in the material and then eventually pump it underground and sequester it. As you can imagine, that is not something that was anticipated by Morton County as a potential land use out in their farmland. And so they don't have anything in the ordinance that covers 800 giant fans in a field. And so what they're looking at now is how do we regulate something that is truly new and not anything like anything we've seen before? I mean, really, I'm not even joking. It's like 800 giant fans in a field blowing stuff through material. And there's nothing like that. There's nothing like that in any zoning ordinance. And so the best that a zoning authority can do is find the next closest thing. Or they can develop an ordinance, which is what I'm going to talk about a little bit. And that's what we're kind of pushing for there and what I'm ultimately going to push everyone to do. But that's one of the issues that a lot of local governments will face. Now, the reason I bring that up is that I heard about some of the comments made, for example, by the developer to the Morton County Commission. And they said, you can't regulate us because of that environmental driven solutions case against Dunn County. They said the oil and gas division regulates. Well, that's got nothing to do with a direct air capture facility with 800 fans in a field. That's got to do with treating plants. And so everything I said was true about the oil and gas division and how much power they have and how they preempt the field. But that was just with respect to a treating plant. 800 fans in a field has got nothing to do with them. And so my point is beware of generalizations because the environmental driven solutions case has absolutely nothing to do with that direct air capture facility. But those county commissioners are getting an earful from people telling them that that case controls. And so beware of generalizations. The other case I'm going to talk about briefly is a Minnesota case. And it's, again, I mentioned earlier that there's been a time when the Minnesota legislature did what they refer to as express preemption. And that's when they just say it. But again, it's not always that clear cut because you have to look at what they said they are preempting. And this case is really, only a lawyer would say this, but it's a really interesting case. And once I tell you about it, you'll understand why only a lawyer would say that because it's not really interesting at all. But it related to a pipeline that was granted a siting permit by the Minnesota PUC. It was a gas line. Sited the pipeline, constructed it, partially constructed under the city of Cohasset. The city of Cohasset said, you didn't get a franchise agreement for that line. In a franchise agreement, I think the folks who work with cities, especially, these are usually used by cities to grant access to utilities to run through the essentially corridors for public utilities under the city. But point being, it was already cited that the route wasn't the issue. It's just that in order to use those corridors, you have to pay for a franchise agreement. And so the Minnesota PUC statute, the law, expressly preempts local control. And it says, I have it highlighted here, the statute is section 216 GO2. And I'm going to read it from the case here, but I also have the statute. But the statute says the issuance of a pipeline routing permit under this section and subsequent purchase and use of the route locations is the only site approval required to be obtained by the person owning and constructing the pipeline. Site approval is important. The pipeline routing permit supersedes and preempts, that's express, supersedes and preempts all zoning, building, or land use rules, regulations, or ordinances. It's important, though, they didn't say all rules, regulations, or ordinances promulgated by local governments. They said all zoning, building, and land use rules. Those aren't the only rules promulgated by local governments. And it's important because you have to, as this court did, look at those three and then look at, is a franchise agreement one of those three? And the court said it's not, actually, because a franchise agreement isn't zoned. It's not zoning. I mean, staying in the corridor is, but that's not what they were saying. They were saying you have to purchase and pay for your franchise agreement to run within the corridors. So that's not zoning. It's not building because it was already built. They already built the pipeline. They were just saying, now that you're in our corridor, you have to pay for the franchise agreement. So it wasn't a building because it was already built. And it wasn't land use because, again, they were already using the land and they weren't telling them they couldn't use the land. They were telling them you have to pay for a franchise agreement in order to use that. And so what the court said is, you know, both the district court and the Court of Appeals agreed with Minnesota Power and not the city of Cohasset. And they told the city of Cohasset, no, Minnesota Power doesn't need to get your franchise agreement because of express preemption. There's two lawyers who think the exact opposite. So always be careful when you're talking to a lawyer and getting advice, because just because one lawyer says something doesn't mean that one 5 feet away won't say the opposite. So careful when you're talking to lawyers. They think that they know everything because we don't. But similarly, you know, you can even win a case in front of the district court and you can win it again in front of the Court of Appeals. And then the city of Cohasset had to go all the way up to the Minnesota Supreme Court before this got reversed. And so you had a lot of really smart judges who got this one wrong too, is my point. There's no simple generalizations, and always beware of generalizations. And so what they did here is say that, yes, that is express preemption, but it's express preemption limited to site approval based on zoning, building, or land use. And so if what the local government is doing is not part of its zoning, building, or land use, this doesn't preempt that by its own terms. And therefore, the Minnesota Supreme Court said, yes, you actually can require that franchise agreement from Minnesota Power, and they had to go and get their franchise agreement. So my point again is just that you've got these two cases, potentially unexpected results, and you would not have been able to predict how this was going to turn out. The Cohasset case, you would have been right at the district court level if you had said Minnesota Power would win, and you would have been right at the Court of Appeals, and then you would have been wrong when they got to the Supreme Court. And so the important part then of, you know, the preemption analysis that I'm really trying to illustrate here is that it's so fact specific. Even if you're saying something is expressly preempted, well, but what is expressly preempted? What specifically? Just the zoning, building, and land use? Or is it everything? Or is it just the zoning? And so even with express preemption, there's still a question. What is being preempted, and is this that? And that's a very fact-specific question in all these situations. And so I'm going to give you one more example, and then I'll talk a little bit more generally. But the final example I'm going to use is this letter from PHMSA. That's the Pipeline Hazardous, oh man, what's in, Sarah might know, and I'm forgetting. Pipeline Hazardous Safety and Materials Administration.
Materials Safety Administration, yep.
All right, it was close. At any rate, that's the federal agency that regulates pipeline safety. And so as several of these large CO2 pipelines have been coming through, there was the Wolf, the Navigator, the Summit. They were telling local governments from Iowa to North Dakota that you don't have any authority to regulate pipelines. You need to just back off because PHMSA regulates them. And that was not only being told to local governments, it was being told to the state legislatures, and it was being told to the courts. And PHMSA disagreed. And PHMSA wrote a letter to all of them. So I've got all three here. And I also, by the way, I'm happy to provide these materials and will do so afterwards. But I have all three letters here. I'm just going to show you the first one, which was their letter to Summit. And basically what PHMSA did is walk through what they regulate, what local governments can regulate, and basically said to each of these three pipeline developers, you're wrong and you need to stop telling people what you're telling them because that is wrong. And then well, the part I have highlighted here is where PHMSA, the federal agency, recognizes local governments have implemented authorities under state law that contribute. But what they're also saying is that they have seen these and they have no objection to this because they don't think that this regulation of land use is conflicting with or being preempted by their regulation of pipeline safety. And so the easy way to think of the difference, I think, is if they were saying this pipeline has to have a specific thickness of diameter and you need to construct it out of a specific material. Well, that is problematic because PHMSA has federal regulations that set those requirements out. And if a local government starts saying you've got to have this, they're really going to very quickly get into a conflict preemption analysis where the local government is telling them they got to do one thing and PHMSA is telling them they got to do another. PHMSA wins that fight. But one of the ones they put on the list here is controlling dangerous excavation activities near pipelines. Well, can a county enforce a one-call obligation? I hope so. And I know they don't always, but and it's not their job. But what if a county just said, you can't just go out digging without daylighting that pipeline with a back truck? So I'm talking like oil field now, but you need a water truck to come in and expose the pipeline if you're going to do any kind of excavation around it, and then you can do your excavation. So if a county said, if you're doing excavation beyond 4 feet within 50 feet of an active pipeline, you need to have that pipeline daylighted before you do that. I don't think PHMSA is going to have a problem with that. That's a good idea. You should do that. And what they're saying is we're not regulating that. We're saying like we're regulating the safety of that pipeline. But yeah, you're right. Counties regulate land uses. And if you got someone who's just going to take off across that field running drain tile and you got a pipeline there, let's have a conversation before you cross that. And so what they're saying with this list of activities is there are things that local governments do that don't conflict with PHMSA, even though they do similar things. And the most important one I'll talk about when it comes to pipe specifically list setbacks and when they say specific building code design or construction standards near pipelines, and then restricting land use and development along pipeline rights of way through zoning setbacks and similar measures. These are things that counties can do. And so one of the fights we're having out here right now with our state PSC is whether a county's setbacks get preempted by PHMSA. Literally, PHMSA said no, and they're still arguing that those setbacks get preempted by PHMSA after PHMSA itself said no, they don't. No generalizations. So even PHMSA agrees with the local governments. But there was a court in Iowa that nonetheless ruled that PHMSA has preemption or has jurisdiction and preempts local control, even though PHMSA itself said we don't. And so you can see it's not as clear cut as one might hope, but I also think it's important if you're dealing with pipelines that you read this letter because this very specifically tells you what PHMSA thinks is preempted and what isn't. So with that, my goal was to really try and convince anyone working in local government or as an attorney for a local government that if anyone comes to you and starts, telling you just categorically you've got no jurisdiction, or categorically the jurisdiction's all yours and no one else has jurisdiction, I don't believe them and I haven't heard anything else. It's complicated. It's always complicated. It's very fact specific. And like that environmental driven solutions case comes down to whether or not it is defined as a treating plant. And if it's not, none of that even applies. And so given all that complexity, what does a local government do? So now I'll finally get to the point near the end here, but we had a radioactive waste facility and we were working with some landowners who had concerns about the facility coming in. And the concerns, ranged from the obvious, which is radioactive waste, sounds scary. That stuff in the air is dangerous. And other concerns from the community were just as simple as you don't have turnouts or turn lanes, and there's going to be a massive amount of traffic going in and out of this facility just hauling because it's a dump. That's everyone in the oil patch is hauling their dump. There's stuff there. And so the county didn't have anything on the books for this kind of a special waste facility. And we faced this issue out here with special waste facilities because in the oil patch, they generate a fair amount of radioactive waste just because they're bringing stuff up from 2 miles below the earth. And there's a lot of radioactive elements down there. And so it gets concentrated and we got to find ways to dispose of that. So as the oil boom got underway, we started generating a lot of radioactive waste and we were shipping it to Montana and down to Colorado and still are in large extent. But as they started trying to develop these waste facilities here, there was obviously a lot of pushback. And the DEQ, or the environmental quality, they developed, regulations for the waste dumps, but local governments weren't prepared for that. So we were up with a bunch of landowners in Williams County, a county up in the oil patch here, and the landowners we were representing were expressing these concerns to the local government. And the local government was having this same issue where they're like, we don't have anything on our books for a radioactive waste facility or special waste dump. And they were hearing the concerns like, you're right, though. I mean, it should have turnouts, but we can't force them to do that if we don't have a law that says that. And there were other things they wanted to do to mitigate some of the issues, like, these radioactive waste dumps. If you get 6 foot of an inert material of dirt that you place on top of everything, and you have high fences and monitors at the corners, it's pretty safe. But the county didn't have the authority in their law to require any of that. And so they were like, I guess it's either an up or down vote, and we don't have anything that regulates this. And so it was a tough situation for the local government. And what I wanted to share with them or share from that story is I think they did it right. And, if you don't have a big controversial issue in front of you right now, now is the time to act, much more so. And Williams County didn't have time to act. They had to react, and they were reacting to something in front of them. But what they did is they put a 1-year moratorium on special waste facilities. But their goal wasn't to kill all special waste facilities in the county. And they recognize that, hey, we like oil development here, but if we want oil development, we got to deal with our waste. And so even folks who were really pro oil development still recognize like we've got to do something about this. And we also recognize there are legitimate concerns about these facilities being your neighbor. And so what they did after they put the 1-year moratorium, and to be fair, it's a lot easier for a county in the oil patch. They make pretty good money in oil booms too. It's a lot easier for them to do this than a small rural county, but there are resources out there, especially in Minnesota, to help, like model ordinances and things of that nature. But they have a West Dakota Energy Association that is a group of counties that work together on these issues, and they pooled together and did a whole study and drafted a model ordinance to address these issues. And a little over a year later, they went back and they addressed that, and they had requirements, conditions on their permit that required things like turnout lanes and buffers and things that they weren't overlapping with the DEQ. They were doing things the DEQ didn't do. But, things like a big fence, we got a lot of wind out here. So, fences and trees can actually close off a facility like this if you get it around in the direction of the prevailing wind. And having, other things like that to control traffic, that actually resolved a lot of the concerns that those community members had. And in the end, we ended up basically withdrawing because our clients were happy with what the local government had done and they were comfortable with it. And there were still a couple that were like, I don't really like it, but, I'm not the only person who lives here. And that's one of the other tough things for a local government is you have to recognize that you're there to regulate land uses. And I work with a lot of local governments whose philosophy is I'm trying to do less. And I fully understand that. But the other thing I try to explain to local governments is that if you don't use jurisdiction and authority, you lose it. And that's what will happen. And so if you want to have that control in order to protect your local citizens, you've got to get out in front of it and use it. And the best way to do that is to be thoughtful about an ordinance. And so whether it's 800 fans in a field or a pipeline or whatever it is, think ahead to how you can more objectively address the concerns you know that'll come up. Because it's easier to do that in the abstract in a way that's going to be fair in the future than it is to do that in response and reaction to a specific facility and the specific issues they're presenting with their facility. Then it looks like you're regulating that facility. If you can get away from that and get out in front of it and pass ordinances that address these things in a thoughtful and comprehensive way, that is going to help everyone, because there are also legitimate rights that landowners have to develop their property. And if someone's saying, I want one of these facilities on my property, it just as it's not fair for them to put in a facility that then pollutes their neighbor's property, it's not fair for their neighbors to tell that person they can't use their property how they want if it's not going to affect their neighbors. So you have to find a balance here. And what I'm trying to say is that balance is often easier to find when you're doing it thoughtfully in the abstract than when you're doing it in response to a specific project or application. And so to the extent I can leave folks with anything, it would be that moratoriums can be helpful, but I see moratoriums as a way to buy yourself time to get out in front of an issue and deal with it comprehensively and thoughtfully versus reactively. But moratoriums that are just stuck up to block development, they don't help the situation. They make it worse. And what I'm seeing out here and what we're seeing is that when local governments push that far and just block things, the jurisdiction starts going up. We're also seeing that at a state level with some of the pipelines, where I've already heard rumblings that because state level siting proceedings in front of the Minnesota PUC or the North Dakota PSC or the South Dakota PUC are difficult because South Dakota denies the permit and Iowa grants the permit. Well, now they're starting to talk about, all right, well, if we can't use state eminent domain and we can't rely on state siting agencies to get it done, then I guess we should move that jurisdiction up to the Federal Energy Regulatory Commission and have them cite interstate carbon pipelines. So that's also a warning to folks that when local governments just exercise jurisdiction to push it to the boundary of let's just block all development, usually what that means is it's just a matter of time before that jurisdiction gets expressly preempted. And so that's why I again say it's much better and more helpful, even if you don't like the development, to regulate it thoughtfully, because that's the way, and the important thing to do, that's the way to weed out the bad actors. And that's the most important thing, is you can get responsible developers and you can get bad actors. And if nothing else, if you can weed out the bad actors with your regulations, you're getting most of the way there. So I'm noticing I'm getting too close to 120, and as you've probably figured out, I can talk for a long time and drone on and on, but I'll give folks about 10 minutes to see if there's any questions. If there's not, I can talk about some other experiences, but just want to pause now and see if we've got questions. So I've saved some time for that.
Thank you so much, Derek. Yes, we'll go ahead and take some Q&A now. I do have one starting question for you. I'll take the privilege of hosting you to take that first question. So you talked a lot about some great examples of citing, things that are cited in one place. And kind of as I alluded to, and as I think, I'm sure you are aware, there's a lot going on in terms of proposals for new or upgraded transmission lines. So how do some of these proposals or like principles that you've talked about apply, or maybe not, to that kind of infrastructure versus something that's cited in one place?
Sure. And it's very similar. And so, the Cohasset case, for example, that was an interstate pipeline. And so, the analysis often looks very similar, whether it is, a linear or nonlinear development, whether it's, one that covers multiple states or counties versus one that's just in one county. What changes is sort of the jurisdiction of the other agencies. And of course, that affects the local jurisdiction. And so when you have specifically transmission lines, and specifically what we call interstate transmission lines, and that's not always really crossing several states, supposed to be. But when you have those sort of linear developments that go through numerous local governments, a lot of times you're addressing the same issues, but I'll use North Dakota as an example. When we're citing a pipeline, we now have specific laws that require the Public Service Commission to consider a lot of the local government ordinances versus those governments being able to act on their own. But there's also still an open question where a county I'm representing in another county, they brought a motion within the proceeding to specifically preempt our ordinances. But they didn't do that to other counties. And so now the question is, well, do they still have to go get a conditional use permit in those other counties? And so back to where I started, it's, it works very much the same, with the exception that when you use those interstate development, or when you have those interstate developments, a lot of times the state or federal, one or the other, has more regulatory authority, and because they have more, the local governments have less.
Great, thank you so much. I think I'm just checking the chat. I think mostly, I don't know if there's anything you want to respond to there. I think some are kind of just expressions. Otherwise, folks, yeah, keep putting questions in the chat or the Q&A. I haven't looked in the Q&A.
So I did notice one, I'll just mention the comment that someone has an ordinance that I lost it. Oh, prohibits any use not expressly listed. And I like that. There's still a little discretion, like, if you have a seed sorting business and they regulate seed drying businesses, is that the same thing? But I like that, and I agree with that. That makes sense, and that also helps you say to the developer when they come in, hey, sorry, we're not trying to be difficult, but we don't have this in our ordinance, and we can't do anything until we do. So let's talk about it. And so I really like that. So let's see, ordinances. So the only thing I can say about solar projects and battery storage is beware of battery storage, because that's something that can very easily fall under some other general provisions, but the battery storage we're talking about nowadays is not what anyone had in mind when they threw something in there about, whatever that might fall under as a general thing. But some of these new developments, that's what you got to think about, is what, when we say battery storage, what does that actually look like on the ground? And that is one where I think getting some specific ordinances in place could be helpful. Let's see. That's a good question. So are there local ordinance related to decommissioning of large projects that aren't preempted in Minnesota? I could probably spend a day researching that. So that's a really good question. I want to know the answer, but I don't have it. What I can say though is that everything I know of, so solar, wind, they're good. So the state agencies are generally going to have field preemption, because at least in North Dakota, the decommissioning for a wind farm, like, that is very detailed and laid out in statute. Now, that said, I have seen, not a full-on decommissioning program, but specific requirements. And so one of the things wind farms try to do is leave everything in the ground that's deeper than 4 feet. And I think that a local government could absolutely say, you don't get to leave anything in the ground when you're done decommissioning. When you're decommissioned, you get it out. That's a fair land use reg for a local government. So I think that a full-on, like, our local government has all of the requirements for decommissioning this project. I don't think that's going to fly with wind and solar. Some of these new projects where they might not have anything at the state level, then absolutely. But I would also be pushing to get the state to do that. And the reason I say that is just there are some things that I don't think are good for local government. And the reason I don't think some things are good for local government is you need a lot of money and resources to hire scientists to do certain types of regulation. And at a certain point, local governments just don't have those kind of resources unless you're one of them up in the oil patch that owns minerals. So counties, to my knowledge, don't have exclusive control. I should be careful though, because I haven't looked at Minnesota's law recently, but Sarah, I'd assume it's similar to North Dakota where there's pretty extensive decommissioning requirements in state law. Yeah.
I'll let you, maybe you want to take Michael Overton's. And then I've got one in the Q&A section for you too.
Yeah, so movement towards standardization, I think that, to be honest, Sarah and Hudson might know more than me, but yes, absolutely, there's a movement. And I know there are folks, boy, I can't remember the names. I can get them to people if they need them, but I know there's folks, for example, that are working on model ordinance for carbon sequestration projects, and that's really more of a North Dakota issue. But I have seen model wind ordinances, and I'm going to answer another one, which is how do counties balance different landowners' interests? And I would just dovetail that with, I think that setbacks in a lot of cases are really helpful. And one thing, a local government, a county commissioner said to me that I thought was also striking when you get into this issue of balance is if you have setbacks and you have a setback waiver, you put a lot more of that power into the landowner's hands. And what you're saying is there's a setback here. But if that landowner, like if you want to pay him to make him okay with that, you can do that too. And what you're doing is kind of giving them the ability to negotiate around some of these things instead of putting the government in the middle of it. And sometimes the best way to find balance is to get the government out of it. And so I apologize to the government folks, but I think that sometimes that is helpful, is just to let the developer and the landowner figure it out. And they often can if you let them.
Thank you. I'm going to read the Q&A one out loud. This is from Vince. So some counties in Minnesota are moving towards using IUPs versus CUPs as a way to approve siting for solar projects. It doesn't seem like an IUP is the best method for this, as it has the potential to limit the amount of time available to the project to be utilized for its useful life. And unlike other types of projects permitted under IUPs, solar projects don't change over time. Thoughts? If you have any.
What, I need to ask a basic question first, but how do they define the difference between the IUP and the CUP? What does I stand for?
That is an excellent question.
Yeah,
I mean,
Vince,
what I'm
can
hearing
you
is
can you put that information in the chat? Oh, there you go. Angie
Thank
got it.
you.
Interim use permit.
Oh, okay. Yeah, it's tough. I literally just had this conversation where we were arguing with this local government about the developers saying, well, we just need a special use permit. And we were saying, no, you need to rezone it from ag to industrial and then get your special use permit, but you got to do the rezoning. And we were talking to the county about that because we were making that argument. And this person from the county pointed out that, careful what you do in there, because if we rezone, so if we just give them a permit, they can only do that one thing. If we rezone from ag to industrial, they can do anything that's industrial. And so my point with that is just, I hear what people are saying with the idea of an interim use permit. And it doesn't allow things to evolve if that's what's going to happen, but they can come back and reapply for something. And so to me, we don't necessarily call it an interim use permit, but we'll call it a special use permit. And it's kind of the same thing, which is this is a special use, and what we're permitting is this use in particular, not any use you have that's industrial. And I think that's good. I mean, when I'm doing easements and leases and things like that, I always try to narrow it down to that very specific project. And I'll even call out like the PSC or PUC proceeding that's permitting it. And so I think, for counties as well, giving a permit that is just specific to that project, I think it's a good way to control that. And if there's going to be issues with evolving and changing projects, that can be dealt with on an ongoing basis.
Great. Well, it is 1:30, so I hate to cut the discussion short, but I just want to thank everybody again for joining us today, and many thanks to you, Derek, for providing such great information. I hope everybody's enjoyed the discussion and learned more about how local governments can engage in siting clean energy in rural places. And again, for those attending this webinar live, who would like to use the 1 hour of Minnesota CLE credit, remember to use the CLE code 503970. And if you're watching the recording of this webinar, please use the CLE code 503929. That will work for on-demand CLE through April 24th, 2026, just as a reminder. And then finally, for those interested in continuing this discussion, please feel free to reach out to myself, or I think either Derek. We will make sure that those emails are in our follow-up messages to you, those who registered. So again, thank you all so much. And we hope you join us for future webinars.